Hello everyone, this is David Fisher, Director and Founder of Immigration Chambers Limited, specialist immigration firm here in Auckland, New Zealand. I'm here today with our special guest, Ashleigh Fechney, who is an employment advocate, employment law specialist based in Wellington, New Zealand. And we've decided to have this online video to talk about employment issues and their interrelation with immigration issues here in New Zealand, specifically during this time of COVID-19, our lockdown. We're going to cover some issues like the wage subsidy. We've got a few questions from some of our clients about their specific situation that we're going to cover, and we're going to have a general chat. So welcome, Ashleigh. How are you today?
Good, thank you. Thank you for inviting me here.
Oh, thanks for coming. No, it's really good. I noticed that you've been doing some interviews on Radio New Zealand, some question and answer sessions. It seems that you have a similar philosophy as we do, and that is that really the focus is to help people, right?
Yeah.
To be ethical, to provide the right advice, and to essentially make sure that people can navigate their way through things effectively.
Yeah, absolutely. I think I first came under a lot of popularity after I noticed that no one was really talking about the wage subsidy scheme in normal people terms. You can read the declaration, but it's not easy for most. And only a few days into lockdown, I published this article about the wage subsidy scheme, and I got about 15,000 hits within a few days. And really, since then, my thought has just been, just get information out there, because people deserve to know in easy terms what their rights are during this time.
Yeah. No, that's right. And I guess, like I said, that's something that we have in common. And another thing that we have in common, I found out, is that we both come from a law background. You studied in Christchurch. You have a Master of Law, is that right?
Yep, yeah, I've got my Masters of Law, and I did pass with honours down in Canterbury. I've worked as a lawyer, I passed the bar, but now I've just chosen to work as an advocate, because I feel like an advocate forum is, I'm able to best help my clients, reduce costs. It's easier to just help the system.
Yeah, okay. I mean, look, this is something that we see all the time in our field, that employers don't act in good faith. They make unilateral decisions. And quite often, look, I've even heard immigration lawyers and advisors try to defend this position too, that quite often the employer will say it's cultural. And I had a conversation recently with, now this is a specialist immigration lawyer. He's a friend of mine. And he made this comment that, hey, look, David, it's cultural. And I said, well, that might be something that you can say, because you come from that culture of the client, the specific person that we were speaking of. They were both from that same ethnic culture. And I said, well, that's fine, but I see culture differently. Culture is your music, your language, the food you eat, how you gather at certain occasions. We have laws here that protect employment relationships, and culture doesn't really come into the mix at that level, does it?
Absolutely. In the same way, essentially, the law is the law. The law is not what morals are. The law is not what culture is. The law is the law, and we have a really well-established system. And in terms of, I know the words fair and reasonable sound really vague, but we've got years upon years of case law and ideas about what that means, and that doesn't impact on maybe what's cultural in New Zealand and what we consider to be fair and reasonable as developed over hundreds of years, but it's a pretty fair baseline.
Sure. So these are clients of mine who are, you could say, stranded. This is the word that they use. They're stranded back in their home country, and they work for a big employer here. This is a big employer, and there is a huge imbalance of power with these guys. Just to give you the background in terms of immigration sense, these gentlemen, some of them, the ones that we're really wanting to talk about, are on what's called a work to residence visa. Now, work to residence is a special visa category that's available for people who are either falling under a special category of talent and meeting the requirements, or who have a job with an accredited employer. Accreditation under immigration means that they've gone through a process whereby the Ministry of Business, Innovation and Employment have assessed the business. It's financially stable, it has good human resource practices, good employment practices, good immigration practices. And they certify that the business can therefore offer jobs at a certain threshold of income, and the person who gets that visa will be eligible after 2 years in that employment to convert it to residence. So it's effectively a pathway to residence by way of that employment, different to other categories where you have to go through the points system, satisfy the normal requirements, education, qualifications, all of that kind of thing. So it's kind of like a golden ticket. If you are working for an accredited employer and you get that right salary, it's magic. And employers often, they know this, and they play that game of, I'm the sheriff, I hold the power, I've given you the visa. Now, I don't know that that's the case with the employer, that they're intentionally holding it over these workers, but the situation is they've gone home to their home country for a holiday, and in the meantime, the lockdown happened. The country they are in actually shut down before New Zealand did, so they haven't been able to come back. Now, initially, the employer had said straight away, like, your job is over from tomorrow, effective immediately. They had tried to invoke some immediate termination clause in the contract, and then they went back and they liaised with the employer and said, hey, look, what's going on? Can't we have some time? And they've been given a date in May, and they've been told effectively that if you can't make it back by that date, you're out. Now, the employer hasn't claimed the wage subsidy for these people. They've just gone straight away to redundancy. What's your feeling about this generally? Now, I know we can talk about this a little bit off camera in more detail, but what's your feeling generally about people who find themselves in this situation?
There is a lot to consider, and I think the starting point is to remember that any decision that the employer makes must be fair and reasonable in the circumstances. So some of those circumstances to consider is, first of all, an employer can apply for the wage subsidy for a migrant worker who is trapped overseas, but only where that migrant worker had planned on a temporary stay. So if they already had annual leave booked in, if they've gone home because of COVID-19, then they won't be eligible for the wage subsidy. Okay. So that's one thing already to consider about whether it be fair and reasonable. The government's going to fund these people for a period of 12 weeks. So that may be a bit early. The second thing is to consider the nature of the business. Can the business, say, easily find replaceable staff? Do they have casual workers? They have temp workers? How easy is it for that just to prolong that decision? Because sometimes it's just a matter of timing. They say they will terminate in May, but what if the borders open up in June? So what they've really got to protect themselves with is that they've made that decision at the right point of time, considering everything else that's going on, and then at that point they might be able to consider it. Other factors, whether these workers can work from home in India or where they are. I know that this might bring about some jurisdictional issues, but that is another thing to consider. I think short answer is I don't have one. It will really be factor specific about whether an employer can terminate the employment. But the most important thing I think for the employee is to engage in conversations, discuss their ability to get home, what they're doing, the steps that they're taking. Ask for a period of unpaid leave if they're not going to apply for the wage subsidy, because if you're on unpaid leave at that point and the employer can refill your role, they can easily get temp workers and casual workers in. It's going to be quite hard for them to look to dismiss straight away and ask for more time.
Tell me, in your experience, now obviously this is in relation to having a visa and the impact of the decisions on that visa, but let's imagine that there are other circumstances that are unique to a particular employee, whereby the decisions made by an employer and the way that they go about their negotiation with the employee have an extra disadvantage on the employee because of their unique circumstances. Do you find that the courts tend to bring that into the discussion of what's reasonable and fair under the circumstances?
Absolutely. So part of the what's fair in the circumstances also includes the circumstances of the employee themselves. So for example, let's just throw a left ball that if you've got an employee who is deaf and they go through a disciplinary process, of course there's going to be an expectation that there might be a sign language interpreter or someone to help them. So there are always different aspects you've got to consider for every single employee, and the employer still needs to make fair and reasonable decisions based on those facts.
Right. And so what I'm really getting at is, in this particular case, obviously the loss of the employment, outright redundancy, has such a serious effect on these people because they are migrants, because they hold a visa. And not only does it mean that they'll be without a job after this, and that they'll be in the same job market trying to find a new job as everyone else, but they may not even be able to come back to New Zealand, where they have a tenancy agreement, they're supposed to pay rent, they may even have other family members here, or other commitments. They've got a car, they've got, some of them have lived here for 7, 8, 9, 10 years. So in those particular unique circumstances, do you think the courts or the authorities would be looking at that and saying, hold on a second, this employer should have done more to try to retain the person?
Not necessarily. And that's only because when you're looking at redundancies, every person, it's supposed to be about their skills and their employment, not necessarily how it's going to impact them afterwards. But the impact after dismissal, it comes under that like hurt and humiliation head of remedy. So when you raise a personal grievance, there is a tax-free sum that you may be awarded, which helps to compensate you for how hard it has been to find a new job, the situation that you personally have been in. It doesn't necessarily stop how that decision making is made, but it does help with remedies after.
Look, obviously, in terms of these particular cases, you wouldn't be able to comment, but generally speaking, under similar types of circumstances that are happening today, do you think personal grievances are a reasonable avenue for people to start looking at?
Oh, absolutely. And I think if someone has been dismissed or they've had some unfair treatment, they should consider it, but they do have 90 days from the date of that action. So you've also got a bit of time to really consider your options, consider if that's what you want to do. There's no, I guess, incredible rush, but it's absolute deadline of 90 days. And once you're outside of that, it's pretty hard to raise a grievance.
Sure. Yeah, okay. Well, I think that's quite helpful for a lot of people because, as I mentioned earlier, a lot of migrants, they don't want to rock the boat. They feel afraid to take any action against their employer because it may affect their visa. And the reality is it does. The reality is, unfortunately, you can, even I had a conversation with somebody this morning who had assisted the ministry with an investigation against an employer, and the ministry then, or the immigration then uses the information he's provided to help them against him to decline a visa. So the reality is that migrants are disadvantaged on both sides. They get hurt by the employer, and then they get hurt if they do try to take their rights through the normal processes and avenues. But now that we're experiencing this situation, you're finding people are up against the wall. That they've reached their wits' end, and they're starting to look at these avenues. So it's quite helpful to talk about this. Personal grievances are going to be a thing that's a much more hot topic for migrants, I feel.
Oh, definitely. And for everyone, I can't tell you how many I've had to raise in just the past week alone. There's definitely been a lot happening.
Yeah.